All right, I think we're good to start. Welcome everyone to Subrogation 201, Wrongful Death Cases, Best Practices for Best Results, presented today by Matt Stevens. Matt is a shareholder and manager partner of litigation, operations and finance for Russell, Oliver and Stevens, PLC. Matt has practiced law for over 20 years and has been with the firm for over 18, handling health plan reimbursement matters on behalf of employers, plan fiduciaries, and third-party administrators. Matt is a frequent speaker on ERISA, FEBA, Medicare, and other health plan subrogation and reimbursement topics at conferences all around the country. So thank you, Matt, and go ahead and take it away.
Hey, thank you, Jackie. Appreciate that very much. I also want to thank John, Jen, Michael, and Phil for putting on a great BLG seminar this year. It's virtual and it takes a lot of hard work behind the scenes. So well done, guys and girls, and it's been enjoyable so far. I was thinking about how long I've been doing this. Jackie, you say 18 plus years. And back in 2004, when I started handling health plan subrogation matters, I had 3 kids at that time in 2004. I had a 4-year-old, a 2-year-old, and a 1-year-old. And this year, that 4-year-old and that 1-year-old will be graduating from high school and college on the same day and the same time. And so it's just amazing how quickly time flies. And there's a lot of people here grown through the last 20 years with us, seen every year as we go out to different venues for this NOPLG seminar. And one thing I'll say, if you're new to the NOPLG, which there are some that are new, you're surrounded by a lot of very smart people that love subrogation, and I always say it's like a subrogation family. So next year, looking forward to being in person. I think it's in Seattle, which is going to be a lot of fun. But talking about college kids, if you signed up for this session and you're kind of reluctant because it's a 201 session, just remember that 201 just means sophomore in college. So we're all fine, I promise. But no matter how long we've been doing this, some have been doing it longer than me. Some of you have probably been doing it less than a year. We can all learn something as we move through this. But that's sort of the point. So as we go through this topic, and honestly, I picked this topic because it is the hardest, in my opinion, to maneuver through. We're going to focus on self-funded ERISA plans because I think that only increases the complexity on how to handle and maneuver through a wrongful death subrogation case. As we do this, the goal here is to create some common elements that you can take home, that you can jot down during the session so that you can apply these to each and every wrongful death case that you have. And what I've done is I've taken a lot of law, a lot of factual information, a lot of decisions, and compacted that into some common elements that I think will help. So again, we're going to talk about some real cases we've handled, cases other people have handled. We're going to talk about how to ultimately obtain the best result possible with these problem cases. But hey, as we move through this, feel free to ask questions. There's a chat box, I think, and I think Jackie will let me know when a question comes in. I appreciate you attending this seminar, and I hope you get something out of it. So let's move to the next couple of slides over. Let's set up the case here. So what are we talking about? The wrongful death subrogation case. So the first thing I'll say is that let's look at number 1. A health plan member has died as a result of the liable third party's negligence. Well, we have a sensitive case. One point here, as we get started, it's okay to be sympathetic when you're on the phone with these members' attorneys and talking about the case. These are sad, sad cases normally. You've got cases where children were hurt and killed, potentially. You've got cases where parents were in the car with them and they're also dead. This is a very grim type of case. So go into it with a sympathetic heart and a sympathetic tone when you're talking with these members' attorneys about the subrogation lien. Wrongful death and or survivorship claims are brought against the liable third party by the attorney for the heirs. Okay, so with that being said, know the difference between the two. Okay, wrongful death and survivorship claims are vastly different. One thing we're going to talk about is under state law how different that can be. But again, we're going to talk about how to use common elements to combine those two claims and figure out the best way to proceed. And what is the best approach here? Again, you don't know the facts. All the facts are different in each case. Information is key. We're going to talk about the top 10 things to know, right? As we move through these things. And there's some more common elements to write down. You want to develop a rapport with the member's attorney. This is very key in any subrogation case, but especially here. I can tell you that on the hardest cases, if you, at the beginning of the case, develop a good rapport with that attorney, that member's attorney, you're going to be way better off at the end of the case. And that leads me to the next, but probably the most important element here with best approach is get there early. Okay. The problem is with most of these cases, sometimes the plan doesn't show up until after everything sort of happened. Maybe right before there's an allocation or right before there's the probate court is about to, hand out and divvy up the money that's available. Next slide, please. So be there early. Before we really get started into this, I think we're going to graduate from being sophomores in college under this 201 to first-year law students. So I thought some important terms were important, obviously, to talk about before we really get through this. Decedent's estate, okay, or decedent rather, the person who's died. That's pretty simple. The decedent's estate is the real and personal property, assets, liabilities. But focus on this: all rights or claims a decedent leaves behind at death. Okay. That's the focus of really today, the rights and claims the decedent leaves behind. An heir, obviously spouses, children, siblings, etc., who have the right to inherit money from the estate. The probate court is where the claims related to the decedent's estate will be adjudicated. That's where it'll all happen in probate court. The personal rep is the person who is in charge to administer, to be the executor, to manage the will, so to speak. Proof of claim, and this is really important here. We'll talk about a case in a little while where the plan was late. They had not filed a proof of claim in a wrongful death case. Okay, what do you do in that situation? I can tell you the note there in the parentheses, debts existing prior to death general, is really the most important thing there. Most of the state law dealing with proofs of claim are for debts that arise prior to the death of the decedent. Why is that important? Because under a self-funded ERISA plan, you've got a reimbursement action, right? That reimbursement action doesn't even arise until the plan, until there's a recovery from the tortfeasor, the person who caused the death. Once that happens, then the plan has a lien. So a lot of times you can argue, we have successfully, that because the plan did not file a proof of claim, they were not prohibited from making a recovery later because the debt, so to speak, didn't arise prior to the death. The debt under the plan's terms arose once there was a recovery from the tortfeasor in that case. Next slide, please. Loss of consortium. This right here is important here because loss of companionship, cooperation, affection. Think about this. Always think about, when you think about wrongful death cases, who owns the claims? A loss of consortium claim is owned by the spouse, parent, or child. That's who's entitled to that type of claim. Wrongful death versus survivorship action. Okay, some states combine wrongful death and survivorship. Let's talk about what they are. A wrongful death claim is brought against a party by the family or heirs of a decedent. The damages include loss of financial support, suffering, emotional harm, and loss of consortium, and can include medicals. But notice that these are claims that are really brought in by the family or the heirs. It's not a claim for damages that the member himself or herself would have had that member live, versus a survivorship action, a civil claim on behalf of a deceased person So basically claims that the decedent would have if they had survived the accident, medical expenses, pain and suffering, those types of things. And then the survivorship statute is that state statute that allows claims the decedent would have before death to be brought by the personal rep, okay? So as we move through this, notice that the most important thing to remember is whose claims are we dealing with? Let's talk about the plan for a second. The plan is written and is between the plan and the plan participant, okay? The plan terms control the plan participant. They're in privity with the plan participant. This plan is not in privity with heirs, with the family, with someone else other than the subscriber and the members under that plan. So if a wrongful death claim is brought by someone, a family member, someone who is not within the scope of the plan terms, again, these are reasons why you have to pay attention to who owns the plan. Because in that situation, there is no claim if it's a pure wrongful death claim that's being brought by the heirs for emotional harm or loss of consortium. We're going to talk later about how ERISA does not preempt those types of state law claims, okay? And therefore the plan does not control. Again, as we said earlier, we're going to focus on self-funded ERISA plans because I believe that they're the most complex in the situation. Next slide. So the challenges, okay, obviously all states, this is what makes subrogation hard. I see some really good lawyers' names on the list of people who are listening. Chris Aguilar, John and Katie, Jason Suter, Jody's on here. So I know that there's some really good lawyers out here, and the one thing that makes subrogation extremely hard is that you have to know the law in every state in some manner, because you may be dealing with Montana on one day, you may be dealing with Florida another day, because all these cases cross state lines. So the state law varies. So we have to know what the state law is. This is one of the challenges. Another challenge is the plan type and language. As we said, we're focusing on self-funded ERISA, but what does the plan language say? So we always teach this: when you open up a subrogation file, you've got to know the right language to use. You've got to know have the proper plan documents in front of you so that you are operating and knowing what you're going into before you make the first argument or make the first call to the attorney. So know what the plan says. Let's talk a little bit about specifics on plan language. The plan needs to obviously establish priority claim, disclaim common fund and made whole, because in many of these situations, you're dealing with a made whole problem. But also it needs to discuss how reimbursement is allowed, even in wrongful death cases or cases in dealing with the death of a member. Even though the preemption issues still are there, if you can convince a court that ERISA preemption should occur in that case, then what controls is the plan document. So just remember that when we talk about ERISA preemption, know the end game on that. So if the state law is preempted, what then controls the case? And that's the plan document. And then last, again, what if you're dealing with an anti-subrogation state? Well, you're in probate court a lot of times. You're going to be dealing a lot of times with the probate court judge who may be used to being in a state with adverse subrogation laws. So knowing the right arguments about whether and how to make the self-funded ERISA plan preempt that state law is key. Next slide. Okay, top 10 best practices. Now, you may have some other ones that you like, but in my opinion, I think these are the best. They're general, some of them, but there's a few down in 7, 8, and 9 that are very, very vital. So number one, okay, like any subrogation case, I always say good subrogation is good subrogation. So get as much information as you can as fast as possible, because time is of the essence. So last year and the year before that, and I think I've spoken here, this is my 12th time to speak at the NOPLG, and I really appreciate that opportunity each year. But I know that you guys have heard me say before, use the hourglass theme or the hourglass example of a subrogation case. So subrogation case is just like an hourglass. When you get that case, you open the case, you've got that, depending on what kind of case it is, you'll have different amounts of sand in that hourglass. It's going to run out at some point, and at that point in time, because of the Montville decision, you'll be left without a claim if you wait too long. Again, wrongful death cases are tough because they have a lot of damages normally. You've got someone who's dead. Sometimes these plaintiffs' attorneys, they don't need the medical expenses, right, to get the policy limits. Unfortunately, policy limits around the country are low. Policy limits, in my opinion, are way too low. So if I'm an attorney and I know, and I'm a smart attorney, and I know that I can keep medicals out and avoid paying back the lien, but still obtain the but still obtain the policy limits in the case, that's what I'm going to do. So getting to that attorney quickly, setting expectations, creating a good rapport, like I said earlier, is so important. Okay, so don't wait until the time frame is run where the settlements occur. All the parties are waiting to disperse money, because at that point you're taking the expectations of the parties from here to over here, because now the plan is trying to assert a lien. It's brand new to the case. Know the players, all the parties and attorneys put everyone on notice of the lien. This is nothing new. Everybody who trains subrogation professionals, that's nothing new, but keep doing that. Determine your opponent's knowledge base on this issue. Again, you may not get a fight. I would say 10% of the attorneys I talk to really know subrogation and how it works. And about only 1 or 2% of that group really know how it works. Now, sometimes you'll be sitting in a situation where the members' attorneys hire a lien counsel to handle the case. Again, they're going to have a better knowledge base. They're going to, so you got to set their expectations as well. Now, when I said earlier, it's okay to be sympathetic in this matter, I didn't say it's okay to be weak, and it's not okay to be weak. But that is why you've got to set the expectation with the members' attorneys that the plan's lien is valid. We don't want to fight about it. We want to resolve this matter with you. We know there's a limited amount of money here. The plan has rights, and if you try to avoid the plan's rights, then we're going to make you do what you should do, which is have the judge, have the probate court allocate something to the medical expenses, to the survivorship, something where the plan can recover this money that it paid as a result of this bad actor, this drunk driver, for example. I had an attorney tell me the other day that, quote unquote, he can't believe that I do this for a living. And that, how do I do this for a living? Subrogate on health plan claims against injured members. And I told him, I said, well, you have to understand really what the plan is doing here is making a responsible person or entity who caused the damage actually pay for the medicals. I always give the drunk driving example. Drunk driver hits and hurts and kills a family of 4. Who should pay those medicals? Not the plan. The drunk driver, his policy should pay those medicals. Obviously, the most innocent person in that situation is the plan member, is the family. No question about it. But the plan also is an innocent party here and should be repaid. So make the arguments, and like it says in number 4, and see what they say. You may be surprised. You may be surprised by the fact that they're not going to argue that you don't have a lien. Obviously, many times they do. Number 5, obtain the complaint, and if the case is already settled, obtain the release. Now, why are we doing that? The complaint tells the story about what claims are being asserted. And in a minute, we're going to talk about the importance, we have a little bit, but the importance of medical expenses being included in the case when it comes to wrongful death and reimbursement by the self-funded ERISA plan. So if the complaint is arguing and alleging survivorship type claims, as we discussed earlier, claims that would have been brought by the covered member had the covered member survived the accident, then that's an important fact. That makes your job easier as a subrogation professional, okay? Obtain the release. What is the release to? Now, if you're the defendant and you've got this lawsuit against you and you see that you've got issues I've been a defense counsel before, many times in situations, my client has issues, right? So I've got to talk to my client intelligently and explain the risk that's associated with proceeding in this case. Just like, so when we finally resolve the case, let's say my client agrees to pay some money to the plaintiff to settle the case, am I only going to release some of the claims? Am I going to release only the claims A, B, and C and leave D and F out? No, I'm going to ask for a release for all claims because I never ever want to have to deal with this issue again. I never want my client to have to deal with this issue again. So the release is a great place to start when a case has settled. And they are arguing that medical expenses were not included in the case. Okay, maybe the complaint was vague. Maybe they have a settlement that is really sort of general. Okay, it doesn't go into it. Well, the release is going to release medical expenses 99 times out of 100, probably 100 out of 100. So when they've done that, then they cannot argue that medical expenses, they can argue it, but they'll probably lose that medical expenses weren't included in the case. Okay, number 6, wrongful death only if the lawsuit includes survivorship claims. That's what we've been talking about. 7, 8, and 9 are really important. Were the medical expenses claimed, recovered, or released? Okay, if they were, then you can argue that there should be an allocation from the settlement to the medical expenses. Then, and we're going to talk about the success case we had in Florida, where we were in probate court, and I'll talk to you about number 1 here, get as much information, and number 10 here, make sure the meds are claimed or recovered or released. Very vital. Let me explain why. It even comes down to the judge. Okay, even when you're working on the case and the probate court judge is assigned, find out who that judge is. Find out if they're new. Find out how long they've been on the bench. What's going on? How do they normally handle these issues? In the last 10 cases, how many times did they allocate money to a wrongful death in a wrongful death case to medical expenses? Okay, how are they persuaded by the members' attorneys? Who are the attorneys that are before them? Figure out some common elements, because this is what we did, and that is what helped us win that case in Florida, is because the judge was new. Okay, we'll talk about it in depth in a minute, but the judge was new. We knew that. These attorneys in number 3 determine your opponent's knowledge base. These attorneys were not very good attorneys with regard to self-funded or risk plan subrogation and reimbursement issues. I can promise you. They had no idea what they were doing on that. But what they did know is they were trying to stay away from the medical expenses because they knew that's their key to not having to pay back this lien. And it was a lien well in the 6 figures. So that's the thing. You know, what do you think the judge is looking for when they're new? Well, I can tell you that they don't want to make an error. Okay, they don't want any reviewing court to find that they've made a mistake. So they're going to follow precedent like crazy. Most judges do anyway, but you've got some judges out there. I can tell you there's one down in Arizona, for example, that we've been in front of, federal court judge that just simply does not like self-funded ERISA liens, doesn't like them, looks for ways to get around paying the lien. I can tell you this with experience. So just because you have a self-funded ERISA plan in a situation like this, it doesn't mean anything. You've got to know what you're doing and what the judge is likely going to do, and how can you make his or her job easier. Okay, next slide, please. The law, here's the law on this. So what are the nature of claims and remedies available in a state? Well, in Florida, okay, they can bring wrongful death and survivorship. If like we mentioned a second ago, if there's a non-specific settlement where the damages they're not very specific, then the court's got to apportion between the estate claims and the wrongful death claims. Again, which claim, who owns those claims? Does the plan member, had they lived, own those claims, which are the estate claims, or are those claims owned by the wrongful death beneficiaries, the heirs, the family, the wife, the children? Okay, again, those are key questions. The health plan may only assert a lien against the estate claims in court. In Georgia, there's two separate distinct claims, and they can choose which one to bring. Well, we have enough problems in Georgia, as we all know. So I can tell you the attorneys in Georgia look for any way they can to avoid paying a lien, so they're going to stick with wrongful death only. They're going to try to avoid the medical expenses at all costs. I think, many of you other people on this phone call have dealt with those issues. We've talked about them at these conferences. But let's go. Okay, a minute ago, very beginning of the session, I said I was going to give you some common elements, some common themes, some common case law that you can apply to each case to try to make subrogation, or one of the hardest types of subrogation, easier for you. Okay, which is that wrongful death case. So next slide, please. Here's the two cases that federal courts really follow around the country. Okay, the facts of the case are not as important as really the holdings and the generality of the holdings here. But let's talk about these cases for a second. One was in '93, one was in '94. But in Liberty, they did not find ERISA preemption, and we're talking about whether the wrongful death statute is preempted by ERISA. Okay, which is a key question. So in Liberty, it was found that it was not, that ERISA did not preempt that wrongful death law. In McInnes, they found to the contrary that it was preempted. So what's the difference? These cases hold that preemption depends on who is being compensated by the settlement or judgment. So again, going back to who owns the claims. But let's not put the cart before the horse here. So for any state law to be preempted by a self-funded ERISA plan, that state law must relate to the plan. So then next slide, please. So the question, okay, of whether a claim under a wrongful death statute belongs to the deceased plan member or to the beneficiary of the decedent defines the line between whether the claim is too remote to the plan and will not be and ERISA will not preempt it, or whether that will be whether that relates to the plan for ERISA preemption purposes. Okay, so you have to look to the deceased plan member, whether who owns the claim. Does the deceased plan member own the claim, okay, through the estate, or does the beneficiary own the claim? If it's the beneficiary, that's going to be too remote to relate to the plan, and therefore there will not be ERISA preemption. However, if it's a claim such as medical expenses that the deceased plan member would have had he or she lived, then it does relate to the plan for ERISA preemption purposes. If a damage claim, we just talked about that. So the focus is on whether medical expenses were included in the wrongful death survivorship claim. When medical expenses are included, okay, remember what we talked about. Look at the release, look at the complaint, see if they were claimed, whether they were recovered, whether they were released. Don't just, you can also talk to the attorneys that represent the defendant. Many times they'll tell the full story that, oh yeah, they were going after the medical expenses here the whole time. Even though they may not have pled them with specifics, I can tell you when we're on the phone, they keep talking about the medical expenses. Okay, so when no medical expenses are included, the state statute is too remote and does not relate to the plan, and therefore is not preempted by ERISA. Okay, so that is, I know that sounds complex a little bit, but I'm trying to give you something common to look at to apply to each wrongful death type of case. Any questions so far? I know we've covered a lot right now. We've got a couple of slides left, but I want to talk through a few other things. I'm going to talk about the success case that we had. But any questions at this point? Okay, next slide, please. So very important, this is a law continued. Again, how are damages apportioned between wrongful death and survivorship claims? If there's a non-specific settlement, okay, again, there must be an apportionment that's reasonable and equitable. This is the basis for which we handled that case in Florida, and we're able to get the judge to look at other jury verdicts that we presented, other cases that we presented where similar probate courts found that X amount of dollars with respect to the recovery amount should be allocated to medical expenses. And therefore, that triggers the reimbursement claim of the ERISA claim. So how much was the recovery? What claims were released? Every case is different, as we know, but I can't undervalue or overvalue rather the jury verdicts and other case law. If you're dealing, and I'll give you a little aside, I've talked about jury verdicts in the past with regard to Mayhold. Whenever you got a Mayhold situation, Colorado, Arkansas, Georgia, Tennessee, many other states, most other states, look at jury verdicts when they tell you what the value of the case is, because that will actually give you other courts that are in that locale where those juries awarded X amount of dollars in a similar case. Obviously, you're trying to find cases that are almost exactly or as exactly like the case you have as you can find, but those jury verdicts is really what won this case for us. Next slide. So this is a little bit on that wrongful death case that we handled. So there was a lien. I think the lien was a little over 200,000. It was, we were late as far as the plan being filing into the probate action. Okay, the claims, of the debt for the debts that arise prior to the death of the decedent. We had not done that. Now, a little bit on that. So, should you, as an ERISA plan, and this is kind of getting into a 201 kind of point. As an ERISA plan, there's plenty of case law around the country that says you really don't have a subrogation, pure subrogation type of claim. Meaning you can't step in the shoes of the covered member and sue the defendant. There's some central states cases around the country that say that is not valid. That's not a valid claim by the ERISA plan because it's not equitable in nature. An ERISA plan only has an equitable claim, and that is not one of them. So you might say, well, Matt, should we go ahead and file into the probate court action? Because that's really, in essence, making a subrogation type of claim. And I think you should go ahead and do that. I can tell you that in the past, when we have made decisions on especially larger dollar files, I think being early, being involved is better. It is very important. And you shouldn't just rely on the plan's reimbursement claim that arises at the time of recovery. I think you should set expectations of all parties early and often. And I think filing that claim with the probate court, if you can timely do so, if you're there early enough, again, think about the hourglass that runs out. That's a good decision in my opinion. This case was different. The plan had not filed into the probate court action. Okay. The attorneys were making a very, very strong argument that because of that, we have, waived any lien that the plan may have. Well, except when you look at the statute, okay, and the law that they were citing states that, again, the debts have to arise prior to the death of the decedent. Well, again, self-funded ERISA plan reimbursement claims arise at the time of the personal injury settlement, okay? And it's from that point forward is when the statute of limitations for the ERISA plan's claim starts to run. As an aside, I know that in Wisconsin, Ohio, you've got situations where the plan is named in state law cases as a subrogated defendant or subrogated plaintiff. In those cases where maybe the plan doesn't respond in time and there's a default pending, always rely on that your claim, your rights don't even arise until there's been a recovery. And there's some case law on that in Wisconsin, Unisys versus Tim, for example, that fleshes that out. So just because they make an argument, again, doesn't mean it's the right argument. Doesn't mean there's a counter to it. I think you guys are smart. You guys have been doing this much longer than the member's attorneys. I always say this: when you get on the phone call and you make the phone call to the member's attorney, they've got 2 strikes against them. You're way ahead. You've prepared for the phone call. They haven't. They're dealing with the Tom Johnson case over here when you're dealing with, the Sarah Smith case on your case. So they're not thinking about Sarah Smith when they're thinking about Tom Johnson. So look, when you call, make sure you use that to your advantage. Know everything about the case. So this case, again, they were attempting to allocate absolutely nothing to the survivorship claims to avoid the lien. That was their goal, to avoid the lien. The lien was over $200,000. The recovery, as I remember, was maybe $600,000. And so, it wasn't millions and millions of dollars. But what did we do in that situation, right? So that's not reasonable. That's not an equitable allocation to have nothing allocated to medical expenses. We found jury verdicts. We found other case law. We submitted them to the court to persuade and sort of out-lawyer the other attorneys in seeing that there's another side of this coin. We were able to successfully argue that that law that they were trying to apply, that we were late, had no bearing on whether this plan's lien is valid. Again, we obtained a copy of the release and noted that the release included medical claims. Well, how can they say that medicals weren't asserted in the case when they released those medical claims, when they signed that release with the defendant? We argued that, hey, some portion had to be allocated. I think we recovered in the neighborhood of about 140, 150,000 of that over $200,000 lien, which in my opinion is a very good win on that because of the issues that we were facing. Again, wrongful death cases are among the hardest cases to deal with. I'll say this, and it can sound self-serving, but I think, hey, there's a lot of good lawyers that are listening here. If you find yourself dealing with one of these cases, again, the hourglass, the sand's going to run out at some point. You're not going to have any rights. Get outside counsel involved quickly before the time does run out. Making the right argument at the right time is going to be the difference in making a good recovery or a bad recovery or no recovery. So in that case, the court found that the allocation that we presented was reasonable and equitable, and they adopted it. Again, knowing who the judge was, knowing that judge was brand new and would probably listen to outside, influence, so to speak, outside cases that were just like her predecessor would have found out, reasonably allocating medical expenses to the settlement. And we were able to do that, and basically through our motions and briefs, write the order that she ended up drafting. So, I know that that's a lot of information. This is a tough area. Next slide. There's my phone number information. If you ever have a question as to these cases, I'm always around. My cell number's there. I know that's dangerous, but I'm okay with putting my cell number down. But that's all I have. If there's not any questions, then I think we're done. But I'd love to answer some questions. I'll save some time for that, and I'm hoping there are. Yeah.
No questions have come through the chat, but feel free, everyone, to turn on your mic and ask a question if you have a question.
Yeah, so there's a question here. If you can establish that medical expenses were claimed or released, do you ever need to get to the preemption issue? Yeah, I think that if they don't, again, the one thing I always say about subrogation cases is listen to what they're saying. Listen to what the member's attorney is saying. If they're not making an argument as to, okay, the medical expenses were not claimed, or you don't have a lien because we're only asserting wrongful death claims, then you don't need to get to the preemption issue. Remember, these and 99.9% of these cases will never go to court. These are arguments that you can make to give the plan the best chance for making a recovery. But that's a very good question, because many times they do go after the medical expenses, right? I'll tell you one little aside here. We had a case in Arizona wrongful death, there was no question they were not asserting the medical expenses in the case. They were not, asserting any survivorship type of claims. The attorney wasn't going to do it. And then you have to think about, well, what cooperation are you going to have from any of the parties when you get involved out there and try to assert those claims on your own and try to do those things. Sometimes it doesn't work out because you can imagine the family members of the decedent are not going to cooperate with a plan trying to take money from their settlement. So we were trying to, at that point, encourage the member's attorney to try to proceed with, those survivorship claims, making those claims by allowing that attorney to share in sort of like a common fund reduction type of approach. Now that Arizona attorney agreed to that, believe it or not. And he said, you know what, I think I like that. Because then he can recover more money for his client. He can recover more money for his fee, and the plan can then share in money that would otherwise be super hard to get otherwise. So again, that's a quite good question. But any other questions? Okay, I don't think there are quite other questions. Again, write the numbers down. If you need anything, let me know. I appreciate everybody on the call. I miss you guys, and hopefully we will see you guys next year, this time in Seattle. Thanks, everyone.
Thank you, Matt.
Yeah, I think you can. All right, good.
All right, I think we're good then.
Okay, awesome. Thank you so much.
A lot of